I'll start off with EPOs, emergency protection orders. So this is more in the what we refer to as a quasi-criminal proceeding. So what happens with that is that um, the emergency protection order is not by virtue of the criminal code. It is by virtue of the Domestic Violence and Intervention Act. So what that law is, it's a provincial law that allows a person to obtain an emergency order from the court that will essentially be a type of no contact order. So it's available for only those that have been abused by a spouse, an ex-spouse, or a parent of your child. So of course, there are situations where you may have a child with someone that you never lived with or that you never got married with. So it kind of, but it's still considered an intimate partner relationship or a type of family violence situation because it is, in a sense, a member of your family. But it does not extend to people outside of your spouse or the parent of your child. So that is to be contrasted with something that we call a peace bond. Sometimes people will call it a restraining order. But this emergency protection order is by virtue, as I said, of the Domestic Violence and Intervention Act. So the EPO will be issued under that law. And it's simply a call that the person makes. So you call to request the EPO. It goes to the Justice of the Peace Center, which is located in Dartmouth, but the toll-free number, of course, is all across the province. And they're open 7 days a week, 9 to 9, as it's listed on the slide here. So the EPO would stay in place for 30 days. There is a way to apply to the court to extend it, but it is not as simple as simply calling and requesting a new one. You would actually have to file a court application and request for that extension. But the initial call is to be able to speak with a justice of the peace, and they will be able to listen to you. And usually it'll take about an hour, from what I understand from the Justice of the Peace Center. So they will take as much information as they can and then make a decision. And that decision is, in fact, immediate. So it is not a situation where you have to go to court or present evidence verbally under oath or in writing. It's something that you will be speaking to the JOP, the Justice of the Peace, over the phone, and they will make a decision. Once the decision is made, then the police would serve the defendant, the spouse or the ex-spouse. But it's important to make that distinction that it's not a criminal conviction, because I certainly appreciate that some spouses may be concerned about the consequences of telling people that they have been abused, and therefore their ex-spouse could face criminal charges that would lead to a criminal record, and some people are reluctant to do that. So it's important that people are aware that an EPO is seen as an emergency measure to protect you from violence, from further violence. So in a sense, it's indicating that you have been a victim of violence and that you are concerned that either yourself or a family member, your child, for example, would suffer from harm again, from physical violence again. So if, of course, a person does not follow, so the defendant, the accused, the person who's targeted by the EPO, if that person does not follow the EPO and therefore breaches it in the way that we speak in legal terms, so if they do not follow the court order, they could be charged, and that charge would be what we call a summary offense. It would be a situation where the person would be charged with not following an EPO, and that could lead to a criminal record. So that's if they don't follow it. That's up to the police to decide if they're going to charge the person. If the person does get charged, or the partner, the other parent, then there's, as I said, it's a summary offense. So there's a maximum, which would be $5,000 fine or a term of imprisonment of up to 3 months for the first offense. If it's a second offense, then it gets to be a $10,000 fine and a maximum of 2 years imprisonment. So the first, though, has a mandatory or has a maximum of a fine or imprisonment. So that's for if a person did not follow the EPO. Of course, if it's just an EPO, it's just a 30-day no contact order, the person should not have contact with them. And then what the emergency protection order would do is ultimately indicate that the spouse needs to be removed from their home. So the first step is to protect yourself, and therefore if you need to, or if you wish to remain in the home, in the family home, then the EPO would remove the aggressor, the person, from the family home, from the family residence, regardless of whose name is on what. That can confuse people thinking, well, I don't own the house, or I'm not on the deed, or I'm not in the mortgage, or I'm not on the lease. Well, all of that is irrelevant. The police would simply remove the person from your home, regardless of whether they are technically the owner or whether their name is on the lease or they're paying the bills. It doesn't matter. They would remove the spouse, and they would be told that they cannot go to your home again or to your place of work. And it could remove any type of weapons or weapon permits and other steps that to protect you in terms of getting custody temporarily, those 30 days of the children, if any are there. Because this is not limited to situations where there are children involved. In fact, obviously anyone who has a child with another person would be entitled to apply for an EPO if they're fearful of for their safety and security. But so if there are children, that the order would target them as well, saying that you would have basically primary care or parenting time with the child, so the custody would be with you for those 30 days. That really the idea with the EPO, although it's 30 days, it's really as a stopgap, as an immediate measure to protect the person, and is not seen as a long-term solution. The long-term solution would be either to go and speak to the police, determine whether charges should be laid, filing an application in family court to get the issues of parenting or exclusive possession or other things that we'll address later on in the presentation. But it's really seen as an immediate stopgap, but for 30 days. So once those 30 days are up and that it's not renewed, then ultimately you're back to where you were. But the idea is that it has given you that time to hopefully decide what is best for you long term. So an EPO is typically going to be applied for by the victim themselves, but it can also be made by a police officer, whether it's provincial police, municipal police, or RCMP, or a victim services worker, which is usually associated with the Department of Justice, or with the RCMP police. They also have victim service workers. So and also designated employees at transition houses, meaning shelters. So FANS is the association. So I know that there's a few questions, so I'm just going to go through that, but I'll simply click here on the brochure. So part of the information that we have here is to provide printouts. This is an older one, the brochure. Let's show you what it would look like. Actually, first, before I show you that, I'll show you what the application is. Ultimately, this is what the Justice of the Peace would be having to fill out to when they're receiving the call. So they would take the information, whether the application is made by the victim and the location of the victim, and then take information that is necessary to make their decision. So this is a form that the Justice of the Peace would need to fill out and then need to send to the Supreme Court Justice. So what happens is this form is completed by a Justice of the Peace, and if the Justice of the Peace decides to grant it, then they will issue this emergency protection order that you have here on Form B, and they will say the issues with respect to granting exclusive occupation of the residence, giving the no direct or indirect contact. What we mean by indirect or direct contact is ultimately to say that you cannot communicate via social media, I remember when I used to work in Bridgewater, there was a person who was, this was like 10 years ago, who was breached for having poked someone on Facebook. I don't think they have that anymore, but anyway, so they're, because it was seen as indirect contact. You're trying to use some other mechanism other than just going face to face with the person. Well, if you intimidate them through family or friends by saying, you go tell your daughter that, or you go tell your son that, or your friend or mutual friend, this, that, and the other thing, well, that's indirect contact, and that's not acceptable. So that's what they mean by indirect communication, whether it's electronically through social media or through family and friends. So this is basically just kind of describing or giving you an idea as to what it is in terms of the information that the accused would receive, or the defendant, I guess is the proper term. And yes, and then there is a pamphlet that I wanted to show as well. Let's make sure that everyone can see that. And then I'll answer some of the questions that I saw popped up. So so there's a pamphlet, but for some reason it's not popping up. A brochure is the term, I guess, that they have. Anyway, doesn't seem to work, but that's okay. It'll be part of it. Basically, it's just giving, it's something that was written back in 2004 by the government to provide people with an opportunity to print them off and hand them out to people. So it's something that, I'll make sure the link is properly fixed, and that when you receive it, you'll be able to see. So I'll try to answer some questions. As I said, I certainly encourage anyone to ask questions. So someone's asking about an application for CPP. What happens on a Canada pension plan? So that's in a situation of a separation that has that may or may not have ended in a court proceeding. What happens is that the Canada pension plan, much like the Canada child benefit, or the old child tax benefit that we used to call, so whether it's your CPP, the Canada pension plan, or the Canada child benefit, the CCB, those are government run programs. And what I mean by that is the courts do not dictate and cannot dictate how a person should receive the Canada child benefit, so the child tax, or how the pension should be divided. In fact, in a divorce order, it will say that nothing in the divorce order will affect a person's ability to apply for CPP, or credit splitting. So what happens with credit splitting is that it basically takes the combined, during the time that you were living together, you apply to Service Canada, so the federal government, and you apply for CPP credit splitting, which will take your contributions during the relationship, so your period of cohabitation, whatever that is. They'll take your contributions and they'll add his or hers contributions, so the other spouse. They'll combine it and they'll split it in two. So it's a way to, essentially, that's how you get your half of your spouse's CPP. Ultimately, yours is exposed as well, but if you're in a situation where you were not the primary wage earner, if your income was much lower than your spouse, then it benefits you. It's not automatic. You have to file the application, but it is automatic once you file the application. What I mean by that is the other person cannot prevent this from happening. The government will split the Canada pension plan regardless of what the other person says. What they are asking the other person is, are these dates correct? Is this the period of cohabitation in terms of the when you live together? And if it is, or if they don't receive a response, then they'll simply do what they need to do at government, at the CRA's level, at Canada Revenue Agencies, and they'll divide the CPP. So it's just a 4 or 5 page document that you complete, providing basic personal information about yourself and as much as you have about your ex-spouse. There is no timeline to apply for CPP credit splitting when you're married. There is if you're in a common law relationship. When you're in a common law relationship, you have 4 years from the date of separation in order to apply for CPP credit splitting. if you do not apply for the CPP credit splitting for a common law relationship within those 4 years, then you can still apply. It's just that the ex-common law partner would have to consent, which we can appreciate that may not happen. But when you're married, if you're legally married, regardless of whether you're divorced or not, but if the period of cohabitation is a period of marriage, and then you were subsequently divorced or not divorced and just still married, that's fine. Either way, there is no deadline. So you just apply for the CPP credit splitting whenever. If you're not in receipt of CPP or the other spouse is not in receipt of CPP, it's fine. It's just going to change the benefits. So how much benefits that you'd be entitled to will increase, presumably, based on the contribution. So I'll just make sure that I have other questions. So one question about the abuse emotionally or financially of a partner. What happens with an EPO is that it is dealing more with physical violence because it is an immediate risk of physical harm ultimately. So that's why I mean that it's a quasi. So the question, sorry for those, I'm assuming people are reading this at the same time, which they aren't. The question was, can you obtain an EPO essentially if you are a victim of financial or emotional abuse? The reality is that you're trying to convince the justice of the peace that you have been a victim of physical violence ultimately, so that there has been, and that the problem with physical violence is that there's a misunderstanding, and that's going to be a theme somewhat throughout my presentation, is ultimately there is a lot of misunderstanding about how our legal system works. A lot of people believe that the law is a certain way when in fact it isn't, or they misunderstand because of how things are done in other countries or even other provinces. But when we're talking about violence, well, it could be a threat that you may not perceive as being something that would be considered criminal, but I would, right, as a lawyer, or a police officer would consider that to be a criminal offense. So, obviously, if there's hesitation, there's no harm in calling the Justice of the Peace Center and explaining your situation, understanding that you may not be able to obtain it, but the other person is not going to be notified. It is not that they call up the defendant or accused saying, hey, just so you know, this was issued, or rather this was applied for and it was denied. They don't contact the other person. So obviously it's managing the expectation. So either for yourself or the person that you're speaking to is letting them know that, they should be as open and honest as they can when explaining their situation to the Justice of the Peace. But ultimately, it's going to be their decision based on their reading of the situation. Some people, they will get into a lot of information about the current situation with family court, for example, and that can be problematic to the Justice of the Peace, saying, well, is this just a way for us to issue an order when it's a family court proceeding happening? So really the focus should be on your physical safety for your physical threats, or if someone starts throwing things around the house, some people may say, well, yeah, but he wasn't violent towards me, just threw a plate or his phone after me. Yeah, but that's violence, right? That's still considered, you can't do that, right? You can't say, well, I didn't hurt you, I just broke your phone, or I didn't threaten to hurt you, I threatened to hurt your dog. Well, that's all violence. So, but if it's purely a financial manipulation, which is wrong, it would not fit within the EPO. Or if it's purely an emotional, in the sense of manipulation, then that's most likely not going to hit the mark in terms of the EPO. But I would never, even if I'm speaking to a person on the phone and hearing their situation, I wouldn't be saying, well, they're going to deny it. It's just letting them know, look, it's possible that they will deny it. So be aware of that, or be prepared that you may not be successful on your claim, because it can be challenging for someone to receive an EPO. Okay, so so when it comes to, someone asked whether, or they feel that, or they've heard that an EPOs are certainly hard to get and that breaches may not be taken seriously. Well, I guess certainly in terms of hard to get, I can certainly appreciate that it's difficult to know with any level of certainty whether a person is going to obtain it. But it kind of falls back onto my previous comment that, you know, there's the only way to know is by asking them to issue it. And if they deny it, well, then, you know, in my view, no harm, no foul. It doesn't, you know, just move on to other options that hopefully will lead to, you know, a proper outcome, and ultimately safety first. And you have to make sure that you have the safety plan, and you know, whether that's reaching out to victim services or transition homes and the like, then that's what you should be doing. In terms of hard to get, or that it's not going to be taken seriously in terms of a breach, well, that is a police issue. And I guess what I mean to say is that, you know, there are different people that will see things differently, whether it's a judge, whether it's a police officer. As I said, there's some misunderstanding about how our legal system works. And we do tend to see this as an institution. And therefore, anyone who interacts with that institution is going to receive exactly the same outcome. But the reality is that we're all different people, and that doesn't change whether we're a lawyer, whether we are a police officer, or whether we become a judge. We're still going to be people. And you may speak to one judge, you may speak to one justice of the peace, you may speak to one police officer, and they may decide to do something that one of their colleagues would not have. I will often say that in the context of court, because, and remind people that our system is based on an appeal of decisions, right? We have a Supreme Court of Canada for a reason, even though the Court of Appeal, which are supposed to be the most prestigious judges, or, you know, the most competent judges of our province, they may get things wrong, where the Supreme Court of Canada may disagree. And even them, the 9 of them that are hearing a case, may disagree. So to say that, well, if you go to court, you're gonna either win or lose, or it's absolute, well, it really depends on the judge, right? And how they perceive the facts, how they were socialized, how they determine credibility. So the same thing for a police officer. If a police officer is speaking to an officer and they're saying, hey, there's a breach, and it is important for a breach of an EPO that you have to be the one to let them know that a breach occurred, because they're not going to know if your ex gets into touch with you. You have to follow that up with the police officer. Whether the police decide ultimately to charge, well, that's no different if I'm assaulted. Are they going to charge me? Maybe, maybe not. It's not really under my control. All I can do is give a statement, and the police will have to decide whether they feel that it's appropriate to charge someone based on the facts that they've received. So that is the situation where that they could ultimately decide whether or not to issue the breach. Is entirely their own, not your own. So someone asked, just in relation to the CPP question, the CPP, if you're married, you cannot, the other spouse cannot deny the CPP credit split, because it's government. Government decides. It's not up to individuals. It's money that the government controls. They advise the other person to let them know, hey, CPP is being split, but that would have to happen regardless, because I certainly appreciate exposing to a dangerous situation, but ultimately, whether they're notified that the CPP application has been put forward or that it's done, I mean, that they're eventually going to know about it. So but it is a situation where they're advised, hey, these are the dates that we've received, confirm or deny, but they can't, it's not a situation where they can refuse the issuing of the CPP credit split. Okay. So in terms of just the peace bond itself, I guess what I will say is that a peace bond is similar to what people believe as being a restraining order, but it's basically all-encompassing. So it's similar to a an emergency protection order, but it's for anyone. If you have a fear that someone will hurt you, and this is a situation where there does not have to be a pre-existing threat or a pre-existing harm. It's simply that you have a fear that you could be harmed, and that can either be by your neighbor, by a family member, or by your spouse. So that is a concern where you have what we call reasonable grounds, which ultimately means if you or I are interchanged, we would both have the same fear, right? So if you take someone and you put them in a similar situation, then they would also have that fear that they could be injured, they could be physically harmed. So it is a threat of physical safety again, because again, this is a criminal code offense, although it is not, or it's by virtue of the criminal code, I should say, but it is not a charge under the criminal code. So once the court decides to issue a peace bond, it is not a person being charged with a crime. So again, it does not lead to a criminal conviction. It doesn't lead to a criminal record. It simply says that the person cannot have contact directly or indirectly with the other person, with the applicant. But it is a situation where it is more, it's lengthier, so they can issue the peace bond for up to a year, for 12 months, but the process is much more intensive in the sense that you have to apply to the provincial court. So you have to go to the provincial court that serves your community. And then you would then go to what we call a conference with usually an adjudicator. So not a judge at that point, a justice of the peace or an adjudicator that would set it down for a trial. So if you're, if I'm applying for a peace bond, well, it may take a couple of weeks before I have my first court appearance. That first court appearance would not be the trial. It would be an appearance with the other party, right? The defendant. They would be there in court or over the phone. Now with COVID, they've kind of moved towards that. But either way, either in person or with the other person there in court on phone, is they basically need to be asked, the defendant, I mean, the defendant needs to be asked whether they are consenting to entering into the peace bond. We'll say that they don't, and they say, no, I don't want to consent to the peace bond. Well, then they'll set it down for a hearing, for a trial, in front of a judge or someone, a presiding justice of the peace, whoever would hear the case. And they will decide whether the person has, the applicant has, reasonable fear for their safety and security, or for a family member, a dependent, whether it's an intimate partner or a child. So if the judge is satisfied, if the court is satisfied that there are reasonable grounds for the fear, and it is important, again, in terms of that reasonable grounds, is that under a criminal code offense, it is the Crown must prove beyond a reasonable doubt that a crime has occurred or had occurred. Under this application for a peace bond, it is what we'll call the civil burden of proof, which is on a balance of probabilities. So you're having to show the judge, or the judge needs to be convinced on reasonable grounds, on a balance of probabilities. Yeah, this fear is legitimate, and they have reasonable grounds to believe that they're going to be harmed. So we're going to issue the what they call a recognizance. That's what the proper term is, and I'll show you what I put a link into the criminal code, because it does provide the section that deals with a peace bond. So a peace bond is under section 810 of the code. So even though it's a criminal code section, it is not a criminal offense, but it will explain what the court is to be looking at. So it's, as I said, it will cause personal injury to them or their intimate partner, or damage or their property. So this is what the person needs to show, is that they have that reasonable fear for their safety and security. And then we'll explain the conditions of the recognizance, or recog, that we will sometimes refer to. So what happens with that is I'll just mention as well, this is the actual application. You would actually go down to the courthouse to fill out the information sheet. So you go down and speak to one of the staff members, and they will help the person complete the application. So this is the form. The informant or the information is the person who's applying for when we're talking about an informant, it's basically an applicant. So they would be, and the complainant is the person who, what I would refer to as the victim, right? So the complainant is the person who's filing the information sheet. So it's just terms that we use in our legal system. So that's what they would need to complete, and they would sign it in front of someone. So it's a sworn statement. Whenever you see this section here of sworn or solemnly affirmed, it's an oath. You have to basically file a document saying, it's usually going to be in front of a JOP. It wouldn't be common to do it in front of a judge, but a justice of the peace would be the one who would be receiving the information. So you fill out the form, you sign it in front of justice of the peace, and this is the first step. And then the police go and notify the defendant. And I should mention that I think I forgot or neglected to mention that that's what the EPO does as well. If the court decides to issue the EPO, then it's the police that will go and serve the defendant. The same goes with the peace bond. So what happens is, it says here to keep the peace and be of good behavior. It's a standard term, basically don't commit crimes is the easy way to say it. So that's the basic in terms of a peace bond, is to keep the peace, meaning don't commit crimes. So if I'm under a peace bond and I commit a crime, then I'm going to be charged with two things. I'm going to be charged with the crime that I committed, whether it's theft under 5,000, we'll say, and for having breached my peace bond, for not having followed my peace bond. So that's what the court would include. That's the standard. But then, and this is what a peace bond looks like. I'll just pull that up. So this is the actual document that the court would complete and issue if the person if the court has been convinced that the person should be given a peace bond because there's a reasonable fear. Then they would complete this document in English and French, basically saying, okay, that the person needs to keep the peace and be of good behavior, but also comply with the following conditions. And then those following conditions are going to be, let's pull that up. It can be a variety. It's called the kind of the supplementary conditions. So the court needs to decide what they feel is appropriate given what has happened. So this is the other conditions of the recognizance. So that's just put in as an attachment. So they would detail that, but I have it listed a bit better a bit simpler in the slides here. So basically they would have to have have no direct or indirect communication or contact with the person. So that's basically the first one that is pretty common, and not have any direct or indirect contact with a family member. So whether it's a spouse or a child of the applicant. But then you can also have situations where a person will be, especially if there's concerns over alcohol use, that they will be told that they cannot have any drugs or alcohol unless it's prescribed medically for certain prescription medication. And they may even need to go in for urinalysis or a hair follicle test or something to provide a sample. So that's something that can be included in the peace bond, is to abstain from drugs and alcohol if the situation warrants it. But that wouldn't be a standard clause. That would be something that the court would need to justify in a sense. The no contact, this prohibiting the contact with or to go to their place of residence or their place of employment, that's pretty much assured. That's ultimately what you're trying to get, is to get that no contact order. This drugs and alcohol, to abstain from drugs and alcohol, is less common. All right. So I know that there were other questions, so I'll just see if there's others that I can answer. Someone asked if there are children involved, whether it would increase the likelihood of receiving an EPO. I will say that in a situation like that, child protection most likely would need to be involved or could be involved. So whenever you have children that have been exposed to violence, that's one of the triggers, I guess we'll call it, under the Children Family Services Act. So the Children Family Services Act is a law that provides child welfare with the authority to protect children, their mandate to protect children. And one of the sections within the Children Family Services Act is exposure to family violence. So if a child has been exposed, of course, it just increases the risk that of harm. So certainly if you have other vulnerable people, including a child, a young child, or anyone under the age of 19, then that's going to heighten the risk. And I would say that, it's a consideration that the Justice of the Peace will need to factor in. However, if there's concerns over violence in a child's exposure to that violence, then it may also lead to a child protection investigation, and then perhaps putting in restrictions on the other parent's ability to spend time with that child. It wouldn't affect necessarily the ability of the other parent to have contact with each other, because the child protection would be targeting protection of the child, not protection of the adult. That's where police would come in. But when it comes to a child and that exposure to domestic violence, then that's where someone would have to advise CPS that, or Child Protective Services, that a child was exposed to violence, and then they could become involved. But it's certainly something that should be mentioned when speaking to the Justice of the Peace, is being completely transparent as to what is happening and what violence has occurred, which can be difficult for victims of violence to relay. It's the form of re-victimization, or the concern would be re-victimization, but it is important to know that you have to be as open and clear to the Justice of the Peace as possible if you're looking to get that, because they need to be convinced. Ultimately, it's the burden is on the applicant to convince the Justice of the Peace that it is warranted to issue the EPO. In terms of the CPP credit split, yeah, I don't really know what a Service Canada agent may have said or not, but I certainly would encourage anyone to just fill out the form, and it's just an application that they do online, and then they just you apply to Service Canada directly, and they will submit the paperwork. But it is entirely their decision, and it's under the law, so they just follow what the law says. So the other person doesn't consent, as long as it's not. Again, I think the confusion may have been if you're in a marriage situation in a common law relationship, there's a difference, and people tend to conflate the two, thinking that marriage and common law are the same thing, which it is not. It really does depend on the law itself. Someone asked for the peace bond if the person does not appear for a peace bond application. That what happens is that when you apply for a peace bond, you still need to convince the court that there is a risk. So the judge still needs to be convinced that it's reasonable. So they wouldn't automatically, they would still need to receive evidence. I guess that's what I meant to say, or I should say, is that the court needs to receive evidence in order to issue an order. Of course, that evidence is not going to be controversial. One of the greatest tools for a defendant is cross-examination, to cross-examine the applicant on their testimony, on what it is that they're saying. So basically to say, well, no, this is not true, or this is not correct, or, and catch them in exaggerating or lies or whatever else. But if they are not there, then the court can issue the peace bond in that person's absence. It's different on a criminal charge. If the police charge someone under a criminal offense, under the criminal code, the person must be there. So there would be a warrant issued, a warrant for committal. So they would go and pick someone up, because you cannot find someone guilty of a crime without them personally being there in person. That's different for a motor vehicle offense. That's different for provincial offenses. So that's where the distinction lies. So if the person just doesn't show up, then the judge can just issue the peace bond, because if they receive the information that they are convinced and that the other person is essentially ignoring the peace bond hearing, well then the court will simply issue it, most likely, unless it doesn't meet the threshold, right? So it's still a threshold that they need to be convinced. Okay, so oh yes, so police, when I'm dealing with criminal offenses, it's important, and I was actually having a talk with one of my colleagues on what happened over the weekend at the Academy Awards. Although I don't watch TV anymore, I certainly couldn't avoid everything that happened and the whole slap and what we would consider in Canada, and I assume what they call in the United States, assault as well. Well, so one of the things that came out of that is, oh, well, the victim, in this case, Chris Rock, said, well, no, I'm not going to have him charged. And that gives us the perception here in Canada that works the same way, which it does not. So in Canada, we do not need the victim to lay a charge or to sign a document or to whatever. It's up to the police, and always up to the police. So when a person threatens another to say, well, I'm going to go and have you charged, well, that sounds threatening, but in fact, what should be said is, I'm going to go and give a statement to the police, and if they believe that they have reasonable and probable grounds to get a conviction, then they may charge you, right? Obviously, that is not very threatening, but it is much more accurate, because it is not your decision as a victim either to have a person charged, but more importantly in this context, to not have a person charged. So if the police are aware that domestic violence has occurred, then we have in Canada, throughout Canada, a pro-arrest, pro-charge, pro-prosecution policy. Basically means if the police determine that intimate partner violence occurred, that an assault occurred in a domestic relationship, they are not asking the victim whether they want that person charged. They may ask them, I suppose, to have an idea as to what should happen, but it is entirely their decision, and they have a policy to arrest the person, to charge the person, and the Crown prosecutor has a responsibility to prosecute the charge. Meaning, if the victim of domestic violence says, they may call me and say, can I do anything to convince the Crown to drop the charge? Can I withdraw my statement? Can I go to the Crown and convince them? And my answer is, well, no, you can't force the Crown to drop the charges, because they have to adhere to that policy of pro-prosecution. Now, in one sense, a person may feel that their voice is not being heard, and I certainly appreciate that. But the truth is that domestic violence cannot be limited to the immediate situation. It is under our public prosecution, it's the government that is charging someone. It's the government, so it's the police that charge. It's the Crown prosecutor, meaning Her Majesty the Queen, who prosecutes. It's not the victim. The victim is providing the evidence, but it is the government that is prosecuting a person. And there's several elements of our criminal system that go towards sentencing, but the whole point of it is to denounce a behavior, to deter future behavior, and to hold people accountable. So the hold the person accountable, well, I guess a victim would have a greater voice on that aspect of it, because if they feel that the person should not be held accountable. However, when it comes to deter and denounce, which are the terms that we'll use in criminal settings, well, we need to make sure that this person doesn't hurt someone else. What happens if they break up or they end their relationship, he goes on to a new relationship and he hurts someone else? The government must protect that person in the future. This unknown person that maybe they would not have entered into a relationship with that person had they known that they had been found guilty of a crime. Or maybe that person would not have, become a teacher and then assaulted a youth, right? It's what flows from those events. They're not isolated events, especially when it comes to domestic violence. So it's not about necessarily only holding the person accountable, but also protecting other members of the public from future violence. So denouncing that behavior, to say, you can't do this, and to try to prevent it, but also to tell anyone else who may be thinking about harming their spouses, look, you do this, it's not about manipulating your ex or your current spouse to not say anything, and no harm will come to you. They will charge you because it's wrong, and that's how our system is built, is to hold those people accountable. Now, it's still up to the police, and unfortunately in that sense, if they are not convinced that that a crime occurred, even though it may have, then they can decide, what, we're not going to proceed with the charges. However, more often than not, what you will be most likely dealing with is a person who is trying to convince or trying to find a way to have the police drop the charge or have the Crown stop the proceeding, but it's not up to them. And if that gives them some relief, then that's good in terms of saying, well, look, this is not your fault, right? I think a lot of victims of domestic violence need to appreciate that as well, and some do. Probably a lot of people don't, because they feel that, well, this is my fault that they're going to have a criminal record. It's my fault that maybe his life is ruined. But obviously it isn't, and we know all that. But it can be difficult for that person in that moment to know. So, is it paternalistic? Is it a bit in that sense of trying to protect a victim from themselves? Perhaps. But the reality is that it's about the society holding people accountable, and that's where that pro-charge, pro-prosecution policy comes into play. Obviously, can be criticized by whichever way, but that's the system that we currently have in place for now. When it comes to the different ways for people to potentially deal with a provincial court matter, so this is a situation where a person has been charged. Well, and I won't go through the links here, but I put them here. This will give you the numbers to the Department of Justice for victim services. So that is somewhere that a person, regardless of where they are in the province, if a person's been charged, they can, if they are the victim, what we'll sometimes call a complainant, but the victim of violence, can communicate with the Department of Justice, and they are acting as a bridge between the victim and the court, the victim and the Crown. So if they want the information sheet, they want the undertaking. So whenever a person's charged, I went over the peace bond and the domestic violence EPO, but when a person's charged with a crime, then they are released on conditions most often than not. They're most likely not going to go through a bail hearing if it's their first offense, or if it's not something that is unusual. Then they will most likely be released on conditions, those conditions will form part of what we call an undertaking or recognizance. It looks very similar to the peace bond document that I showed online. So that recognizance or undertaking is going to prevent the person from having direct or indirect contact. Well, if the accused has it from the police, they're given it in person. The victim does not necessarily get a copy. So if they want a copy, they can get it from victim services, for example. And if they want to know information about, when the person will be attending court, then they can get it as well. It's important to know these are things that may be obvious to some of you, but may not be to people you're dealing with. Is as a victim, you do not need to attend court. You're not, and what I mean by that is until you're subpoenaed to go to trial. So there are multiple court appearances, such as the arraignment, such as the plea, these things that a person does not need to attend as the victim. Police aren't going to be there. It's really going to be the accused and the Crown prosecutor. At the trial, then the Crown prosecutor will subpoena the victim in order to compel them to attend court and to provide testimony. It's important for the person to know that, look, you have to attend court because you're being compelled to come to court. By not showing up to court does not mean that the court will just throw out the case. They will most likely just delay it. They will ask for an adjournment. They'll postpone it, and they'll try to get you back into the court and make sure that you come in and give evidence. But you don't have to speak to the Crown if you don't want to. I'm referring to victim services as a way for the person to obtain the information from the Crown if they want it, but they don't have to. It's not an obligation. The Crown cannot force or compel a witness to speak to them before the trial. So usually a Crown prosecutor will want to meet with the victim in order to prepare them for trial. If the victim doesn't want to, then they don't need to. They still have to attend court. They're going to be subpoenaed. They'll have to attend court, but they don't need to speak to the Crown beforehand. However, if they are looking for what we call testimonial aids, that's something that they can speak to victim services about as well. And I put the link in terms of describing what it is. That's usually, however, in situations where, in situations of sexual violence, so sexual assault, a situation where there's a vulnerability. Any youth who's a victim of a crime, anyone under the age of 18 would benefit from that testimonial aid. So it's essentially a way either that the evidence is being given by way of video link, video conference, or that there are screens in order to prevent the victim from having to look at and to face the accused during their testimony. So there are these mechanisms to try to protect the victim. It's not absolutely given to everyone because they need to balance the right of the accused to see and to basically hear everything that is happening, and so that things aren't done behind closed doors. So they have to kind of balance the protection of the victim and making sure that the testimony is going to be given. They have to balance that with the administration of justice and making sure that that there's nothing happening that would be perceived as being a bias or a concern over the administration of justice itself. The Department of Justice also has a guide for victims that I put in a link. There's videos and whatnot to read through. So certainly encourage you to take a look as well for those that may feel that it's important. Some people have heard of the domestic violence court program. So that's only available for those that have a substantial connection to HRM or to the Sydney area, Cape Breton Regional Municipality. So that's if you're charged with a crime that involves domestic violence, and then you could be referred to the domestic violence court program. But that should not be confused with a way to get a trial but on a domestic violence case. If you are referred, and I should say it's only the Crown that gets to really decide whether a person's going to go to the domestic violence court program. If the Crown prosecutor says, no, this is not a good candidate, then it's not being referred to the domestic violence court. So you can't force the court to give you a date with the domestic violence program. So, but if the Crown determines, yes, that you're eligible, the accused, then the accused needs to voluntarily accept responsibility, meaning they're going to plead guilty. So there is no trial in domestic violence court. It is essentially a sentencing court, which is what I would kind of, we have these types of creations of our court system where provincial court itself, in this case, Chief Judge Williams, Pamela Williams. So Chief Judge Williams, she hears cases at the domestic violence court program, but she's not hearing a trial. She's going to have a Crown prosecutor who's tasked with presenting cases there, and defense counsel who's going to be there. So a person needs to have a lawyer, whether it's through legal aid or private lawyer. So they need to have lawyers involved. And it's about sentencing. It's just that the sentence and the process will be similar to the wellness court for mental health and substance abuse. It's going to be a situation where we're going to try to find ways to prevent a person from oh yes, well, someone just told me that's right. About the domestic violence court program. You're right. There was a change. Thank you, Carolyn. They changed it's no longer Chief Judge Williams, who hears it in Halifax. It's Justice or Judge Sakalakis, who used to be in child protection, I believe. Anyway, so the judge would hear the case for a hearing, sorry, for a sentencing, but really the idea is that it's to try to help a person to be able to rehabilitate and not have to go through the traditional court program or the sentencing. But you're still sentenced in the sense of you will have a criminal record unless there's a discharge, but most likely you would have a criminal record the same way as you would in traditional court. It's just that in traditional court, you're dealing with a probation order and a potential period of incarceration that could lead to more of a house arrest, what we can consider a conditional sentence order and things like that. But the domestic violence court is going to be dealing with a lot more of the emotional, psychological needs of the accused and trying to make sure that it does not occur again. So that's, but again, it just to understand that it is not something that you just go in and say, hey, we get to go to the domestic violence court because I'm charged with domestic violence. You may, but you have to plead guilty or take responsibility, and the Crown has to determine that you're a good fit, ultimately. All right. So, so I guess, yeah, there's a Judge Benton, Kathy Benton, runs the domestic violence court program. So they must be expanding the pilot to Bridgewater, which is good because it used to be just based in HRM, CBRM. But if it's expanding to Bridgewater, that's great. I actually, Judge Benton is one of my favorite people, I would say. So she's an excellent person to run it. Or to hear those issues. So that's a great place to expand to. It certainly is something that is beneficial. Again, it should not be perceived as something that the accused will get less. I mean, the idea is usually with these wellness courts is it's actually a lot more on the accused that they must follow certain things. If not, they're just sent back to regular provincial court and they're going to be sentenced there. But usually it's a lot more time for them to invest, and there's more of a follow-up than just a traditional probation order. So it's not seen as a slap on the wrist from it may be seen as society looking at it from the outside saying, oh, well, they got a slap on the wrist. But in fact, it's going to be a lot more intensive for them to abide by those conditions. And if they don't, then they'll just be thrown back into regular provincial court. All right. So for immigration issues, so of course, the concern is vulnerability, person who's dealing with a person who's applied for permanent residency but has not yet obtained their permanent residency, and that their permanent residency is through what we call spousal sponsorship. So if I am in Canada, but I am on a work permit, visitor permit, study permit, whatever the permit is, and I'm married and my spouse, or I'm in a common law relationship and my spouse, who's Canadian themselves or a permanent resident, sponsors me, then that person, myself in that case, if I'm the applicant, can be in a very vulnerable position because they could withdraw their sponsorship and then I have to leave. So during that window of time, when you're waiting for your permanent residency to go through, then you are really at the behest of your spouse, because if they decide to revoke their sponsorship, because it's two things that they have to look at. The spouse sponsorship for Immigration Canada, the government looks at the sponsor first and determines whether the sponsor is eligible. Most likely they will. They need to be convinced of the legitimacy of the relationship of the common law or marriage. And then they look at the applicant and they decide whether the applicant is going to be granted permanent residency. For those that don't know, permanent residency is essentially the same as citizenship. It's just that you're not yet a citizen, you can't vote, you can't serve on a jury, but ultimately you have all the rights and freedoms that every other Canadian would have. So you're basically Canadian all in but name. So you're really, it just, and some people may eventually go up to citizenship. Some people may be a permanent resident forevermore, and they just decide to be citizen of their country of origin, but continue to live in Canada indefinitely as a permanent resident. So it's certainly something that is advantageous, and one of the requirements, or one of the paths, I should say, towards permanent residency is under a spousal sponsorship, where your spouse, either common law or married, can sponsor you. And then, but it usually takes about a year, if not more, especially with COVID, has kind of extended those filings, but usually it would take a year for the application to go through, 12 months. And during that year, if the person was experiencing domestic violence, then they may be fearful of saying, well, I can't do anything about this because I'll just have to accept and not do anything, because if I leave, then they will simply revoke their sponsorship and I will have to leave the country. And that can be a very frightening thing for people. So it's important for that person to know that they can call Immigration Canada and request for a temporary resident permit. So what happens is, when you're in Canada, you have to have some form of permit. Imagine you go into the States with your passport. What they are issuing you is a visitor permit. You're allowed to come, or if you have an American friend who comes in, they come in under a permit. If you're studying, then you have a study permit. If you are working, you have a work permit. So you have something until you gain your permanent residency. So you have to have one of those three permits. If what you have is an open work permit when you're applying for permanent residency with a spouse. So you're waiting around, and you're allowed to work just like any other Canadian. You're given that open work permit. But if your spouse revokes their sponsorship, then you lose your work permit and you lose your status. You have to return to your country of origin. So you have to, at that situation, you call the Government of Canada, Immigration Canada, and you ask for a temporary resident permit to be issued. They no longer have conditional permanent residencies. That's just to say, we used to have it where you'd have to be married for a year or two after you were given your permanent residency. We no longer have that. Once you become a permanent resident, you can break up with your spouse the day after. It doesn't matter. But the concern here is, in between the application for permanent residency and the granting of permanent residency, there's a period there that you are vulnerable. And if you are a victim of domestic violence, then it's important to call Immigration Canada. It doesn't lead to criminal charges. It's not a situation where you have to give a statement to the police. You just have to speak to the federal government, who is in charge of immigration issues. Residential Tenancies Act, it allows a person who has been designated by Victim Services, so the provincial Victim Services, as a victim of domestic violence, to be able to remove themselves from their apartment. So if you want a year-to-year lease or on a fixed-term lease and you're living with your abusive spouse and they've been charged by the police for having committed that assault, then you can obtain a document, a certificate from Victim Services that you would hand to your landlord, and that basically would trigger a 1-month notice. So you're able to obtain that to obtain it in order to leave the lease, whether it's a year-to-year or fixed term. So again, it's just calling Victim Services at that point to ask them to issue that certificate. So that, but that's in a situation where you're living with a partner who has been abusive. The Labor Standards Code, so another piece of law dealing with your employment. So this is our basic employment rights. There is such a thing called a leave for victims of domestic violence. Basically, if you're past your probation period, which is typically 3 months, right? So if you're working for the same employer for more than 3 months, then you would be entitled to receive leave. Either there's a combination of paid leave and unpaid leave. So you'd have 3 days of paid leave and then a combination of, up to 16 weeks, if you will, of unpaid leave. So basically 4 months worth in order to do things that you need to do in order to make sure that you're safe if you are or have experienced domestic violence at home, or that your child who's under 18 has experienced family violence. So if that's the case, and that really the goal is to be able to seek medical attention if you need it, or primarily counseling and physical injuries, that kind of stuff, but also emotional issues that need to be resolved by getting psychological services or counseling, that kind of stuff. Same goes for either yourself or your child, or if you need to leave your apartment, either temporarily or permanently. So that will obviously take time. But I mentioned before, sometimes people have to go, and if the person is going to plead not guilty and there's going to be a trial, then the person will have to attend court and attend for a criminal legal proceeding, which will include most likely having to speak with the Crown prosecutor preparing for the trial. So that could be a criminal proceeding, as it could be a civil proceeding, because civil meaning family law, most likely. I mean, you could sue. That's not very common, but usually what they're referring to here as civil proceeding would be a family law proceeding. But the criminal legal proceeding is really what would be taking time as well. So that allows you as a victim of domestic violence to get that time off. So you'd be able to get 10 days interspersed, so intermittently, so kind of here, there, and everywhere. But if you need a long period, so 16 weeks of one continuous period, you're allowed to take that. Or if you want those 10 days kind of thrown in around that calendar year. But they do give you 3 days of paid leave in order to get that. That's all through the Labor Standards Code. So if your employer is not providing that leave, then they will, you would call the employment standards, the government, and they would force that on your employer. The employer would need, or can, I should say, for information about what it is. There's a form that that you can fill out. So some employers may say, well, I want to know what's going on. Well, there's a form, that standard form that the government has created. So you wouldn't have to just be unsure as to what it is that you're going to be sharing. But if the employer says, well, I want information as to why I'm giving you this unpaid leave or this paid leave under domestic violence, then you would be completing a form, and this is the link to the form, or you can call Labor Standards and they would give that as well. There's also a link that the government with a link to kind of give information about what the person has the rights to. I'll have to make sure that the link is connected. This guy just tried to click on the link and it didn't show up. So I'll make sure that that actually works, but it's a useful tool. It's Status of Women with the Government, I believe, created this type of interactive or video form to better understand employee rights. All right. So I'll kind of get into the family law for the remaining time that we have. It's just to understand that, when you're dealing with issues of family violence, oftentimes we're concerned about the immediate risk, and we're dealing with criminal charges and emergency protection order. But long term, it is the situation of how does family violence affect the custody of a child, or the residence, the long-term residence for the family, whether you have children or not. So our Parenting and Support Act, now there are comparable sections in our Divorce Act, but I'll speak only really in this case about the Parenting and Support Act. Everyone has access to the Parenting and Support Act. Anyone who has a child or has been living with someone for at least 2 years. So either they have a child, or if they don't have a child, but they've been living in a common law relationship for 2 years, then they have access to the Parenting and Support Act. The Divorce Act was recently changed a little over a year ago, in March of last year. So they have comparable clauses, but this Parenting and Support Act is specific to Nova Scotia, and as I said, applies to everyone. So they define what a family violence, abuse, or intimidation is within the meaning of the law. So every law has a section that deals with definitions for that specific law. So this kind of just defines what the court is supposed to see, or what the legislator defined as domestic violence or family violence. That's just to kind of use as a tool. But with respect to parenting time, so that's the terminology, the words that we'll use now. Instead of custody, judges will favor parenting time now instead of custody, because it was a bit of a confusing language, I suppose. Maybe not as plain language or as direct. So the preferred term now is parenting time. So when the court is trying to decide who is going to have custody, who's going to have the child or children, then they need to determine the best interests of the children or child. Well, that can be a bit difficult for people to understand. What does the judge factor in when deciding what is in the child's best interest? Well, the law itself, the Parenting and Support Act, and I gave you the link to the actual act, so you'll be able to click on it and read through if you want and consult it. But at section 18.6, they specify the things that, well, the legislator specifies what the judge should be looking at when deciding on best interest. So that will factor in, who was primarily taking care of the children emotionally and physically during the relationship, any cultural elements to it, a lot of different factors. But one of them, and the one that interests us today, is the question of whether there's been any impact of family violence, abuse, or intimidation, regardless of whether the child has been exposed. So that is something that the court needs to consider when determining whether a child should be placed with one parent or another. So it's that issue of exposure to family violence, abuse, or intimidation. So there's now been a positive or now an active role that the court needs to take in determining whether there has been family violence. So before it was more passive in the sense that we'll hear about it, but now it's more active in the sense that they're now mandated, the judges, to inquire about it. Now, how they're going to go about doing that on each case, it's really up to them, of course, but they are mandated, the courts, to inquire as to family violence and to consider that as part of their decision when determining what is in the child's best interest. Now, part of that role of the court to determine best interest is to try to determine the child's views and preferences if they can ascertain it. So I mentioned this primarily, it's not so much about family violence, but more about in general. A lot of people may believe, oh, well, there's a certain age when a child gets to decide when they're going to spend time with mom or dad. Some people say it's 12 because I suppose that's when they can babysit, and that's when they can be charged under the Youth Criminal Justice Act. Other people think it's 14 or 16 because of child protection legislation, that kind of stuff. But the reality is there is no age. And that can be surprising to some parents, but the reality is that my child doesn't decide when she goes to school. She's 9, so it makes sense. But when she's 16, she's not technically deciding. She should not decide for herself whether she's going to school or not. And I can force her to go to school the same way as I can force her when she's 10 or 12 to go to school. It's just at some point, I'm no longer going to be able to force her. And that's more about a child's ability to assert their independence. But it's not about them actually having the decision-making authority. They don't get to decide when they're 12 whether they're going to school anymore. You're going to force your child to go to school, or that's at least expected of you to force your child to go to school, the same way that it's on you as a custodial parent to force your child to go to the other parent's home, if it's court ordered, regardless of what that child may want. And the child may have what we call a voice of the child report, which is this mechanism that the court can, and a parent can request, and the court can agree to have a counselor or someone who can interview a child and to determine what that child wants. There is no age per se, but I would say that the court would be very reluctant to get a voice of the child report for a child under the age of 10 or 12. Case law will certainly lend itself to that, where judges are going to be reluctant because what's the point ultimately, right? Because the voice of the child report is just another piece of evidence for the court to consider, but it's always going to be up to the judge to decide, regardless of whether the child is 15, whether the child is 12, or whether the child is 6. The same way that they can apprehend a child and place a child in permanent care and custody when they're 15, meaning that they can be apprehended and placed in foster care when they're 15. It's not their decision. The same way that the court will issue an order for a child to detail or decide where they're going to spend time, even if there's a voice of the child report. Because in fact, the Court of Appeal in Nova Scotia has said very explicitly that a judge cannot use the voice of the child report as determinative. They cannot solely rely on, well, that's what the child wants, and has actually overturned decisions where there was this perception that the judge had decided, well, the child wants that, so that's what the child gets, and did not justify why or what else was it beneficial for the child to have that type of parenting arrangement. So if a child wants a certain thing, well, that's useful, maybe, but even that, you are putting a child in a very uncomfortable position potentially, right? They're exposing the child to conflict, to litigation, and that may not be appropriate, especially if there's concerns over, a child being overly exposed to that type of conflict in that litigation. So the court always has the decision at the end of the day whether to issue the order or not for the voice of the child report, if they feel that it will be useful to the court, because ultimately it's the judge's decision. And if they feel, well, look, even if the child said, I want all of this, would that factor in the judge's decision making? If the judge is like, well, no, it wouldn't, then why put the child through that type of stress of having to say to the court and ultimately to the other parent, I don't want to be with you, right? That can be very detrimental to the child's relationship to the other parent, even though it may be true. So that's where the court will have the final say. So I just wanted to mention that because a lot of families do get a bit confused about what a child gets to decide, even in a situation of family violence. That's a situation where it's up to the judge in a family court proceeding to decide what is best for that child. So when we're dealing with exclusive possession, I had mentioned before that the EPO is, its main goal, the emergency protection order, is to give you that immediate protection, that immediate exclusive possession of the home. But that order is only going to be good for 30 days. So whether you can get the EPO or not, the idea is that you should be at some point filing an application to the family court to request for exclusive occupation of the residence. And that doesn't matter whether you are the owner or not. We make a distinction between ownership and possession. I may own an apartment building. I don't get to come in at 3 a.m. and walk into the apartment just because I own it, right? Because I don't have possession. So the idea is that the court can issue an order that will give one person exclusive occupation of the residence, give the exclusive possession of the property, whether it's a matrimonial home, whether it's a rented apartment, whether it's a duplex who is owned entirely by the other spouse. The court can issue a temporary order. Usually, it's what we call an interim order. Usually, they would issue a temporary order with a view of having that reviewed later on. So it's something that a person can do, whether they have a child or not. It's not something that is only limited to children. But of course, if you have a child, then it will certainly factor in. So this is the section of the Parenting and Support Act that deals with that. Section 7.2 will basically deal with the idea of best interest of the child. So if the child should be in the home, that's where the child should be, to not disrupt the child as much as possible is the goal of the court. Whenever there's been a relationship breakdown and there's a child involved, the court tries to make it such that the child is not disrupted as much as possible. So if the child is ordinarily cared for by parent A, and parent A doesn't have her name on, or doesn't have his name on the lease or the mortgage or whatever, but that is the parent that is most often taking care of that child, and that is in accordance with the judge's decision is in the child's best interest, child should be with parent A, then parent A is most likely going to get exclusive occupation of the residence, right? And that doesn't matter who has money or not. That's child support. Just pay child support. If parent B has all the money and is paying all the bills, great. They'll continue to pay all the bills because you're a parent of a child. So you're going to transfer that through child support so that the other parent can continue to maintain the style of living for the child as much as possible. However, if there are no children involved, well, then the court will look at other factors, such as the financial circumstances of each party. So, who can find alternative housing, right? If I have my mother who lives down the street, well, most likely I should be the one moving out and not my wife, right? But also, if there are situations of domestic violence, then that will be a factor in determining whether one person should have exclusive occupation of the property or not. So that's one of the things when it comes to a finding of domestic violence. It is a factor when determining exclusive occupation of the residence. And then quickly, because obviously when we're dealing with concerns over family violence, there can be a knee-jerk reaction. Well, that's not really what I meant to say, but there can be this perception by us as frontline community workers to say, okay, well, you need to leave and you can take your child because you're a victim of family violence, then you can go and just take your child and go. Well, yes, we want the person to be safe, and we want them to find that security that they need to be able to take their child and be in a safe environment. But that is very different than taking your child and leaving the jurisdiction, leaving the province, leaving the ability of the court to issue an order against you. So you have to be very careful when you're dealing with relocation. The court doesn't, or the law does not specify a parameter in terms of what is the distance in terms of kilometers or county lines or provincial lines. They simply deal with the question of whether there's going to be an impact, a negative impact on the parent's ability to spend time with the other child. So if you're a victim of domestic violence and you take your child and you go, you live in Halifax and you go off to Yarmouth, well, I mentioned before, a judge may believe you, a judge may not. If you go into court and you say, well, I left and I went to Yarmouth because I've been a victim of domestic violence, the judge may say, I don't believe you. And the judge may say, your child is now going to be placed in the care and custody of the other parent. Because the reality is that there is a way to, the court, of course, to leave the relationship, but not leave the county, not leave the court's jurisdiction, not leave the province. So if you start taking your child and going to a place that makes it difficult for the other parent to spend time with the child, then you are going into a very compromised legal position in court. There's an old expression that it is better to seek forgiveness than to ask permission. This is not the case in relocation. It's very important for me that parents know that if you are going to relocate, then there are specific provisions within the law that tells you what you need to do. And if you decide, because, well, I'm a victim of domestic violence, so I'm going to move back to New Glasgow, back to my family, and I'm going to leave the spouse, the abusive spouse, and leave, 200 kilometers away. Well, you may not convince a judge that was the right thing to do, and the consequences are quite severe. So the steps to notify the other parent, and it's important to know that this is a notification requirement, not a request of permission. So you're not asking the other parent for permission. So this, of course, is a situation where you are deciding to relocate, but you're not living with the current spouse, because this only makes sense, really, in my view, if you're looking to relocate, but you're not living with the current spouse, the current other parent. So either it's a court-ordered contact time with grandparents, or that it's with, or whether there's no court order with parents. So what I mean by that is they say an order for contact time or an order for parenting time. The idea is that the Parenting Support Act applies to any person who lives in Nova Scotia with children. So whether you have a court order or not, you need to notify the other parent, right? Regardless of whether the name is on the birth certificate, regardless of all of that, if it's clearly the parent, you can't get out of it by a technicality. That person is the parent. You need to notify that parent on a relocation request. If there's a court order that gives someone else, a grandparent, a niece, or sorry, not a niece, an aunt or a sibling or someone, contact time, so they would be court ordered, so they don't have an inherent right, they don't have an automatic right, but they have a court ordered right to contact time. That's what we call extended family contact time. If they have a court order, then you have to notify those people as well. But for parents, you always have a right to parenting time. So whether you have a court order or not, if you are going to relocate your child to the point where the other parent cannot have their ordinary contact time with their child, their parenting time, I should say, court ordered or not, it doesn't matter, then you need to give them notice. So the notice needs to be in writing, text message, email, whatever. There's not a Dear John letter. You're just having to write it. So electronic means is good, and explain them that you're going to be relocating in on whatever date, and this is the new place I'm going to be staying at, and this is my contact information, and this is what I'm suggesting for a change to the parenting time. So that time should be delivered, that notice should be delivered as soon as possible, but at least 60 days in advance. So if you are planning to leave sooner than 60 days, then you have to go to court. If you are leaving after 60 days, then give the 60 days in advance notice. And that notice is, just as it was written here before, the ABCD. You have to give those 4 things in writing to the person and say, this is when I'm leaving. If the other person says, no, you're not, well, I didn't ask for permission. I simply said I'm moving. But if they file a court application, then it stops it. So they have a month to file a court application. But if you go in and simply provide the written notice and they don't file a court application, then you're able to move. You haven't done anything wrong because you've given the other parent the written notice, and you have proof of that because it's in writing, right? It's not, well, I told them over the phone. No, you have a written document that clearly says these 4 things, and you've given them at least 60 days. Now, of course, if you're in a situation where giving notification would create a situation of family violence, for example, or it's just not possible to wait for those 60 days, then you would apply to the court to ask to waive the notification requirement or to change it, to reduce the 60 days. But it is not an after the fact situation. You do not relocate and then go to the court. You can move out, but moving out is different from relocating. When I'm talking about relocation, I mean you're making a substantial move. You're taking your child out of jurisdiction in a sense that you're taking the child elsewhere. So that's where you have to be careful with that when you're explaining these issues with vulnerable clients. So they should be giving written notice. If they cannot, because there's a concern over family violence, then they should apply to the court. It's called there's a Latin term that we call ex parte motion. So you can file a motion without notifying the other party. So you yourself simply go into the court and say, this is the reason why I cannot notify the other person because of family violence, etc. And I'm asking the court to issue an order in the absence of notice to the other person. So there's a process that you can go in, whether you speak to us or call a lawyer. They should be able to give you that direction. Okay. So I'll just finish up this and then I'll answer the final questions that people have put in. I certainly encourage anyone else because I know it's getting past the timeline, but just to finish up, in terms of denial of parenting time, there's a concern over the idea of being able to deny the parenting time, and that whenever you have an order, that it would be absolute. The reality is, regardless of what the enforcement clause may say in a parenting order, an order from the court, the police are not going to enforce by policy. If there's no clear criminal charges, there's no family violence that they clearly see, then the police are not going to want to get involved in a civil matter that is a private matter between parents, which is what family court is. When a child is apprehended by Child Protective Services, yes, the police are there, but it's not the police apprehending the child, it's the child protection worker under the Children and Family Services Act. The police do not get involved in taking children from family members when there's no reason to from a domestic violence situation, right? If there's domestic violence, that's one thing, but if not, they're not breaking down doors to take children from the care of a parent. There are charter and rights and freedoms, and the police cannot just randomly walk into your home if they don't believe a crime is being committed. And not following a Parenting and Support Act order is not a crime, the same way that not paying your visa bill is not a crime. So the police are not going to enforce actively. They may try to passively, they may try to go in and convince people, but they're not going to break down doors to take children from an order. And the reason why, ultimately, and that can be confusing to some people, I appreciate that, but the idea is that you can deny a parenting time, even if it's court ordered. It's not whether it's wrongful or not. So my example that I often give is, if I go to pick up my child from her mother, and I'm drunk, and I'm driving my car, but it's court ordered, it's Friday, it's 5, I have to pick up the child, I'm allowed to, but my ex-spouse says, nope, you're not taking our child. Well, is that wrongful? Well, no, of course not. She should not release my child in my care when I'm drinking and driving. That's obvious to us, but is that a denial of parenting time? Yes, because she's denying my court-ordered parenting time. But is it wrongful? Of course it isn't, because my child could be placed in harm because I was impaired by drugs or alcohol, right? So that's the obvious one, but the less obvious one is a reasonable belief that the child would suffer family violence, abuse, or intimidation. So again, the issue is, how do you prove that? Well, what I tell parents ultimately is, you can't know with absolute certainty what a judge is going to do. So ultimately, if you decide to deny the parenting time based on your concerns, then you have to be aware that you will most likely have to stand up in front of a judge and explain why you denied the parenting time. So if you can stand by that, regardless of what the outcome may be, then you make that decision whether to deny or not deny the parenting time. But you have to make that decision as a parent, because there's no way of knowing whether the judge is going to believe you or not. But if you believe that there's a chance, there's a reasonable belief that your child will suffer family violence, abuse, or intimidation, then you have, under the Act, the ability to deny the parenting time and to justify that as being not wrongful. So that's where family violence comes in terms of denial of parenting time. But it's just important to know that the judge will have to, as a parent, you'll have to explain yourself to the judge if the application is put forward, and you do your best, as any other parent would. You try to explain what happened. Just in terms of child support, I just put in the section here about the table. It's a family issue whenever you're dealing with child support. That is the right of a child. So any child under the age of majority or over the age of majority, but they're in university, college, or they have a disability that prevents them, then they're going to be able to receive child support. Spouse support, so that financial support, being able to leave a relationship and obtain the financial support. Well, if you have a financial dependency, then you should be applying for spouse support to gain that financial independence. So to be able to continue. So if you're leaving a violent situation, you are entitled to spouse support if you are dependent or were dependent on the other person. So these are the sections of the law that deals with what the court needs to look at. So what are the what are the factors that the court considers when determining spouse support? They'll look at these sections dealing with spouse support. So it's important to know that the person has the right for child support if they have a child, and if they were financially dependent on the other spouse, to apply for spouse support and to get that financial support. One thing that is not listed here, which is important for people to know, is that one of the clauses within the Divorce Act is spousal misconduct, meaning we may believe, oh, well, this person was violent towards the other, they perpetuated family violence, therefore they should pay more spouse support. But spousal misconduct is not something that is considered when determining spouse support. So when you're dealing with financial support, it is not a situation where you can claim for spouse support if you were a victim of family violence. It's not punitive. Spouse support is not seen as punishment towards bad behavior. It's seen as being able to make sure that the person does not suffer financially because of a relationship breakdown, so that they need to leave the relationship because of whatever reason, that they should not fall to poverty. And it's important to know as well that there is no principle of abandonment. You do not abandon any rights by leaving the relationship. You're not abandoning your entitlement to half the property or half the bank accounts or entitlement to spouse support if you leave the relationship. So some people, unfortunately, may feel trapped, that they think, well, if I leave, this person is violent towards me or abusive by whichever means, I need to leave. But if I leave, I may lose everything because they've told me that I'm not going to get anything if I leave. Well, that's not true. That's absolutely not true. The spouse support would still trigger. It's just you don't get more because of the abuse. But that doesn't mean that just because you ended the relationship that you wouldn't be entitled to spouse support. It's not about that. Same goes with right to the house. If you decide, you know what, I have to leave, I'm not safe here anymore, and you decide to leave the home, yes, there's a mechanism to apply for exclusive possession because maybe you want to stay there, but maybe you don't. Maybe you feel unsafe living in that family home. Well, you're not abandoning any rights to ownership. You're still able to apply and receive equal share of the property if you're entitled to it. Same goes for spouse support, regardless of who ended the relationship or who did what to whom, whether it's adultery or concerns over the violence that may have occurred or anything. That it's not going to factor into the spouse support or the division of property. It's gonna lend itself more towards poverty and preventing people from falling into poverty, especially when it comes to feminization of poverty, which is something that still exists even though it's been around for so long. So I wanted to, and I want to thank everyone for kind of bearing with me here. I know I'm way over the time that was allotted, but I think it's important to try to give everything I can in terms of the information. I'll try to answer some of the questions. Just a reminder, I think it's been said multiple times, this is all recorded and the PowerPoint presentations are going to be sent out as well. So you'll be able to consult them. I certainly encourage anyone to ask any questions and to feel free to remain on. I'm not in a rush, so I'll try to answer as many questions as I can here as they come through. And I always encourage anyone, if they have questions that they may not feel comfortable asking through the chat, if you want to send a question to me via email, well, that's why it's there. You certainly feel free to send an email and I'll be happy to send a response. So, so one person is asking with respect to people taking the child and going to another province. The concern I always have is, I think that when you are dealing with a court and you take a child and you go, even if it's an hour away, the reason I don't specify, or that I specify that the court does not deal with kilometers or county lines or provincial lines, is if you live in Amherst and you are moving to Olac, well, that's a pretty quick jump, just a couple of kilometers, but you've changed provinces. But that's that may be comparable to someone moving from Dartmouth to Cole Harbour, right? Or maybe better, Fall River to Halifax. It's not a substantial move. We wouldn't really consider someone moving from Halifax to Bedford to be a big distance, because you're all within Halifax Regional. Whenever you're dealing, however, with a change in jurisdictions, and what I mean by jurisdictions is the court has counties that they are responsible for. So the family division here in Halifax deals with Halifax County, Halifax Regional Municipality. The Bridgewater Justice Center deals with Queens County and Lunenburg County. Shelburne and Yarmouth is out in Yarmouth County. So they're all kind of tied together, right? So Amherst deals with Cumberland. So if you're going to take your child and you're going to leave and go to another jurisdiction, I think that at that point you're always in a precarious position. And I would always encourage a person to provide the other with the notice requirement, but stressing the point that this is not a request for permission, that they are not asking the other person permission. Of course, if the person gives them the permission, then great. It doesn't need the 60 days notice because the person has consented to the move. But of course, what I will often end up hearing from people is, oh, well, they're refusing to write it out to me, but they told me on the phone that I'd be allowed to go, but they don't want to write it in an email. Well, why? It's because they're going to use that against you. They're going to file an application. I never said her anything. I never told her that she can move. She's just making it up. So I would be extremely careful about that. And I would say that you would want to err on the side of caution, because of course, if he doesn't or she doesn't file an application to prevent the relocation, well, the court is only gets involved. The family court only gets involved when people request that they become involved. So they themselves are not filing their own application. There's never a requirement to go to court in family court or otherwise. So the court is going to respond to an application. So if you are planning on relocating to another province, then I would always say to a person, you really should file an application. It's just that the difference in distance, if I'm moving from Yarmouth to Sydney, well, that could be quite substantial and have quite an impact versus someone who moves from, Amherst to Olac, or Sackville, New Brunswick to, or from Amherst to Sackville, New Brunswick. I mean, that distance, it may be very easy to compensate for. So I would still say they should file an application to court if they don't have the 60-day timeline. If they have 60 days, then at least give the notice and see what happens. All right. So the situation with respect to change, whether the situation may change, the reality is the relocation clauses are relatively new. They came in, the Parenting and Support Act was changed in 2017. It used to be based on case law, meaning it wasn't something that the legislator had specifically written in. And to me, I feel that now that it is listed in the Parenting and Support Act, that judges are much more, or at least based on the decisions I've read, are much more requiring parents to abide by the law, because ignorance of the law is not an excuse. So if it's written in the Parenting and Support Act, then it's clear, it's obvious from the judge's point of view. Obviously, from a parent's point of view, it isn't. It's not like we read the Matrimonial Property Act before we get married. It's not like we have a child, but before we have the child, we have to memorize the Parenting Support Act. These are things that are missing in our educational system. But the reality is that if you go in to the court, they're going to expect you to follow the Parenting Support Act. In that Parenting Support Act, those provisions, those sections of the act were brought in 4 or 5 years ago. So I don't see it changing, but they are updating the Parenting Support Act because the Divorce Act was recently changed as well. So the idea when it comes to the safest way to notify is to provide that motion to the court to ask the court to do away with the 60-day notice or to completely waive the requirement to notify the other parent because of concerns over family violence. But at the end of the day, you don't do it without going to court. At the end of the day, you may not need to notify the other parent, but you do need to notify the court. Do not tell the judge in your actions that you don't care what they say, right? Which is not what the parent would be saying from their point of view, but it may be what the judge is interpreting is that they are kind of usurping their authority to make a decision over a child and trying to avoid taking the child outside of the court's jurisdiction, outside of the judge's authority to make a decision about them. So it's always to file a court application, even if it's not to file an application to, or rather a notification to the other parent, at least file an application to court and ask permission. So what grandparent rights? What happens with grandparents is there is no automatic right to custody, so parenting time, because they're grandparents. What they have the right to is an ability to apply to the court. So oftentimes when I'm dealing with explaining family law purely as a family law, not family violence, but if I have more time to deal with family law questions, I usually will explain that whenever we're talking about rights, it's not necessarily the right language that we should be using, because it's not so much what are my rights, but rather what is my ability to apply to the court for. If I want to divorce my wife, I can file a petition for divorce. But my mother cannot apply for divorce, right, for me, right? That's as obvious to us. In China, apparently, it is. I spoke to a client who she was quite surprised and could not understand why the mother of a adult son could not apply to divorce her child, to have the children divorced. Ultimately, it's because you don't have that right. You don't have the ability to apply to the court. So what the grandparents have under the Parenting Support Act is the ability to apply for custody with the judge's permission. But when it comes to contact time, meaning being able to spend time with the grandchild, then they have the automatic right to apply to the court and seek that contact time. However, a uncle, aunt, extended family member, sibling, whatever, they need to ask the court's permission whenever they want to bring in an application of, concerning a child that is not their grandchild or their own child. So a grandparent has a special right to apply to the court for contact and interaction time without first requesting permission to bring in that application, whereas everyone else would need to first ask the court permission before bringing forward an application for contact and interaction time. However, if the grandparent wants custody, they want parenting time, quote unquote, then they first have to seek the leave from the court. So they need to get permission from the court before bringing that forward. And yes, thank you, Kelly, for specifying ex parte motion, because I was probably mumbling there. So it's Latin ex parte, which means without notifying the other party. Okay, so I think I do agree with respect to the police clause, that it's unfortunate for the parents. I specify that part of it is to manage expectations. Part of my role, I feel, as an educator, as a teacher, is to manage expectations for people. Is that, you know, they should, if you read the court order, they may believe that the police are going to intervene when they will not. So it does create stress, and it does create a person to believe that something is going to happen when it doesn't. So it is unfortunate that that is not necessarily the case. The reason, though, is that it's ultimately, you could, the other example I would use, I use the alcohol example. The other example would be a parent who doesn't see their child for a year or a year and a half, but they have a court order that says that every other weekend they get to spend time with the child. And then all of a sudden they pop in and say, hey, mom, for example, I'm coming this weekend. It's my weekend. I'm going to go pick up our child. Well, you haven't seen the child in a year or two. All of a sudden you're going to take that child. Well, the parent would be able to say, no, you're not. You haven't seen our child for a couple of years now. Imagine you're taking a 3-year-old or 4-year-old who hasn't seen their parent for 2 or 3 years. All of a sudden they say, well, I have a court order. I'm going to take our child. The other parent should deny the parenting time because it's not safe for the child in that scenario. But the police would find it very difficult to try to sort out those facts, right? They're going to be hearing different evidence or different statements from different people. So it's not to put themselves in that type of compromised situation where they may place a child in harm's way when they don't realize it. So it's just a concern over a child and erring on the side of caution and just saying, you know what, if you guys have a problem, you should go to a judge, right? Yeah, so in terms of, when it comes to judges, I mean, ultimately they're all, it's like any other member of society, I guess. That's where I usually try to remind people is that, we're all, whether we're a lawyer or a social worker or a doctor or an RN or a police officer, we're all human ultimately, and we'll have our own limitations, our own perceptions, and that's where it's important for people to know that the courts are not there to determine the truth. The truth is very difficult to establish that with absolute certainty. They're trying to make a decision which is what they feel is the best one. Not everyone will agree with that, and that's why you have to be aware. And again, in terms of managing those expectations, that just because you believe it to be a certain way doesn't mean that the judge, whether it's a criminal court judge or a provincial court judge or in a family court, that they'll agree with you. So it's always important to know that. So when it comes to supports that are available for a parent when you have a court order, unfortunately, there isn't any other resources that are currently in place in order to enforce those orders. It's an issue of having to go back to the court, in that that's why the court really does push that parents reach an agreement, because you're much more likely to follow an order that you have consented to than one that is imposed on you. So it is a situation where it's a civil matter. It's not something that is criminal, and therefore it's going to be limited to the parents in acting appropriately in the best interest of the child. And if they don't, well, then they run the risk that they could be facing court orders or cost awards, so financial. That's really where the court can use its stick, if you will, if you make the analogy between a carrot and a stick, is financial consequences to the parent, saying, well, you're going to suffer financial cost because of not following these court orders. And the ultimate stick would be, well, we're going to now have to change the parenting schedule, so you're not going to have as much time with your child because you're making it an unsafe environment for your child, and that you're not accepting to ensure the contact time between both parents. But that is something that the courts deal with, and that's going to take time, unfortunately. You can ask the court to deal with things on an urgent basis, which is called a motion for interim relief. So you can ask the court on an urgent basis to say there is something that is time sensitive that would be needing a court's decision within weeks and not months. But it wouldn't be days, right? If it's not an emergency, meaning that a child is not being kidnapped or is not being placed in physical harm's way, then it will still have to be a matter of weeks, whatever that turnaround is, 4 to 6 weeks or 45 days or whatever the court has in terms of their turnaround time, depending on your area. But it is something that the judge will have to make a decision ultimately, and it would go through family court. Unfortunately, there are no real other options that are available in terms of family court order. So when it comes to options for people that are not charged, but there are concerns with respect to the contact with their ex-partner. I guess the idea, maybe I'm misunderstanding the question, but ultimately it would be that you'd be applying to the court for financial support. So the idea is that if the family court has a broad range of powers to issue exclusive occupation of the residence to a person and to continue to live there for a considerable amount of time, for months, or if it's a lease, until the end of the lease, and to compel the parent that has the financial means to financially support the other parent, and therefore, even though they may not be living in the apartment, to pay spouse support in order to pay the bill. Usually the court would not direct a parent to, or a spouse to, pay a specific bill. They would usually direct the spouse to give them the financial support. There's a couple of reasons why they would do that, mainly because it would be seen as a form of manipulation if you had a parent say, well, I'm only going to pay groceries. Well, it shouldn't be up to them to decide what they're going to pay for. You give the other person money, they decide how to spend that money, whether to pay those bills with that money or pay groceries or pay whatever. But some parents or some spouses may say, well, I'll pay spouse support, but I want to dictate where that money goes. I want to know where that money goes. But it's not up to them to know. It's a financial support issue. So they give money, and then the money should be paid towards those bills. So that's, I guess, the question with respect to being able to pay the bills, or if their name is on the lease and it's paying the bills and all the rest. The court can issue an order to say that you're not allowed to go to your place of residence, or even if it's a home that you own, it doesn't matter. They still have to, they would still have to be not able to live there anymore to go to that place of residence. They would get, the other parent would be able to change the locks and say, no, you're not coming to our place. As for as a child protection, so Jennifer has mentioned a child protection worker. I'm just wondering, so as a child protection worker, given for permission, to ask for an EPO. I think that's what you're referring to, Jennifer, in terms of asking for an EPO for child protection social worker. You wouldn't be a designated person to apply for an EPO. You could, you wouldn't be able to apply for an EPO on behalf of a parent. You would have to direct them towards the police or a transition home to be designated, but a social worker would not have an inherent right to apply for an EPO, if that's the question that you were asking about getting verbal permission. What I would say is that if you're on the phone with the other parent, with the parent rather, and they pass the phone on to you, you could, if the justice of the peace allows for it, then you'd be able to speak on their behalf. I guess that's what I would say on that, but I'm not sure if I properly understood your question, Jennifer, so certainly feel free to Oh, sorry. Okay, so no. As a what I guess what I would say is that as a child protection worker, just because you specified what happens on the issue of the moving the jurisdiction, you would have to use your authority under the child protection legislation, and you would be designating her as a protective parent, and you could support her by way of a motion, sorry, by way of an affidavit in her motion to relocate and to waive that entitlement, so she could file an ex parte motion. So if you want to move, if the person wants to move to another jurisdiction, you would be able to say, look, you need to file a motion to the court asking to be able to relocate, and then you would file an affidavit on their behalf in support of their motion, and you would be confirming that you're a child protection worker, and that you've determined that this person is needing to, or they should be waived their requirement to give the notice requirement because of concerns over family violence and harm to the family. So if it's not something that triggers the agency's involvement to take a supervision order or take a formal position through the courts, and then you would be there in support of, I mean, you can obviously speak to the other parent and use your powers of persuasion as a child protection worker to try to discourage them from preventing the move. But realistically, I would say that you would be there as a support to the court. This is something that you know, but maybe will benefit others. Some people will say, or will ask, family resource centers or other social workers may say, who has more authority, the judge or the child protection worker? Well, ultimately, it's always the judge, right? We always know this as people that work within the system, but those that don't may misunderstand that if a child protection worker or any social worker says, well, I'm giving, I agree with you that you should do this, they may misunderstand and believe, oh, okay, well, the child protection worker said I could, so therefore I can. But it's always up to the judge. And that can certainly be very powerful to have a social worker, a child protection worker specifically, or another medical social worker, someone else who will support and validate those concerns of family violence for the judge to see that there's an independent third person who says, hey, look, this is not just someone saying this. This is someone who's in the home, who's interviewed them and says, yeah, there's violence. Yeah, there's concerns. And yes, we as protection workers, or I as a protection worker, believe that there's family violence and this person should be able to leave for the benefit of the family. That will play a large part. So to me, it's really more applying to the court to get that, but it wouldn't be, it's really important to notify that, or to know the distinction between filing an ex parte motion, which is asking the court for a quick turnaround, right? I mean, the whole idea is I need to move within 60 days. So you're bypassing the normal turnaround of court. But it does require evidence, which certainly can be intimidating for someone who doesn't have a lawyer. And if, as you mentioned, if legal aid doesn't have someone to help them, then they're going to have to do it themselves. Certainly, I always try to encourage people to do it themselves if it means, or the alternative is, I'm not going to do it whatsoever. I think it's important to reassure people that they are able to file an application on their own. And yes, it may be better to have a lawyer. It may, but it's not a requirement. And some people can advocate for themselves quite well. Others may need a person that we call an assistant. So they can ask the court to have a friend or a family member, someone who they have trust in, to advocate for them, to be appointed their assistant, so to be given permission to speak to the judge. So if you have a family member who's quite articulate, or at least, maybe a bit more removed from the process, and they are going to be able to advocate for you, then you can ask the court um, to, to accept them as your assistant, and that person would be able to speak to the judge and to act in a sense as your lawyer. That's an alternative that not everyone will know about, but yeah. So the idea is that if there's a situation where they need to file an application, it's not the ordinary timeline that will take months before it's resolved. It'll take a shorter time, because the court appreciates that this is a time sensitive question that they should turn their eye to quickly. So I think those were any all the questions. There's one last one about the no contact order within their spouse. Well, I guess whenever you're dealing with CRA and the need to file their taxes jointly, well, to me, they would be filing they would file their taxes, but indicate on their own and indicate that they recently separated, and therefore they're filing their kind of revenue agency personal tax information independently. They wouldn't require the other person. So they may say, well, you need to file jointly in the sense of you're in a relationship, but it's just indicating that you are no longer in a relationship and that your relationship status has changed in the fiscal year, and that should allow the person to simply file their taxes on their own. But in terms of whenever you're dealing with a no contact order, one thing I didn't mention, but I should mention now, is that the no contact order, and I never encourage people to contact the person who is or has been violent towards them, or has an undertaking or a no contact order. But it is important for the person to know that the no contact order is not reciprocal. It is the accused or the defendant that is that has to follow the no contact order, not the victim. The victim is not bound by the no contact order. If they need to, for some reason, communicate something to the other person, then they're allowed to. It may not be the best idea. It may put their safety at risk. So obviously that's where the concerning part is. But I wouldn't want to infantilize anyone and say, well, you can't communicate because I'm trying to protect them from themselves. They have the ability, they have the right to communicate with the other person. It's the other person that is not allowed to answer. But if they need to communicate something by means of a friend or a family member and say, hey, you need to tell person X, or the abusive person these things, then you're allowed to do that, regardless of whether there's an undertaking, a no contact order, or whatever. As long as you're not the one listed as the accused, then you can speak to whomever you want. Whether it's a good idea, really up to you, I suppose. I often make the analogy that what it is a shield, right? What it is to protect yourself from violence, and if you don't use it, well then it may not be very useful. But yeah, the idea is that you could, if they need information from the other person, well, they can ask for it. At the end of the day, it's through a lawyer. You can always communicate with the other person through a lawyer. So if there's any concern and they have a defense lawyer, then you can speak to their defense lawyer, or if they have a lawyer assigned to them in family court, then you can speak to their lawyer. That's not seen as direct or indirect contact, so it wouldn't be in violation of the undertaking or no contact order. But again, the no contact order is one way. It's the accused that doesn't have the right to speak to the other person. So I'm not sure if there was any other questions. I'm not sure if I've answered all of them, so I apologize if I missed any. But certainly feel free to send me an email if you have any, and certainly if anyone has additional questions, I'm more than happy to take the time to answer any questions. And I think, as Kelly has mentioned in the chats before, it's going to be sent out the recording and the PowerPoint slides, most likely by way of a PDF, and share it to whomever you wish, the links and all the rest. I tried to create a form as well, a bit of a quick sheet that may benefit some of you to quickly see what the rights are for certain laws that are in place. So we'll try to send that out as well as part of the emails that we'll send out. And any feedback, positive or negative, especially anything constructive, is certainly beneficial to me. So I encourage you all to let us know if there's any ways that we can improve these sessions. So I thank everyone for joining us today. Okay.